The most familiar common law doctrine is the concept of employment at will. Although most countries worldwide allow employers to dismiss employees only for cause, in the U.S., employment is predominantly at will in all states except Montana. At will employment was explained by Justice Ingersoll of the Tennessee Supreme Court in the Payne versus the Western and Atlantic Railroad Company case of 1884, when he stated, either party may terminate the service for any cause, good or bad, or without cause, and the other cannot complain in law. This definition allowed employers to change employment conditions at their sole discretion, whether to hire, transfer, promote, or terminate an employee. At-will employment simply means an employee can be dismissed for any reason, good or bad, fair or unfair, as long as it's not unlawful. And a common misconception was that at-will employment relationships meant the employee didn't have rights. However, it allowed employees to leave a job anytime, with or without notice, and all the federal, state, and local labor laws still apply to an at-will working relationship. The usual rights to negotiate a raise, apply for workers' compensation, participate in protected activities, and be free from discrimination still apply. Employers can't use at-will employment as a pretext for terminating employees for discriminatory reasons as outlined in equal opportunity legislation or other legislation designed to protect employee rights. Even if an employment agreement contains an at-will provision, there are certain reasons why terminations could still be wrongful. There have always been exceptions to at-will employment based on employment contracts. Employees under contract or those represented by a collective bargaining agreement are not employed at will and may only be dismissed for specific reasons. Further, varying by state, the doctrine began to be eroded by both court decisions and statutes, resulting in several exceptions to the at-will concept, including public policy exception, the application of the doctrine of good faith and fair dealing to the employment relationship, and the concepts of promissory estoppel and fraudulent misrepresentation.